Hey everyone. So we turned in an answer to the defendant's lawyers proposed order to declare me a vexatious litigate. So he sent me a letter through email that he attached the order for my approval, and that if I disapprove, that I would have to give it within 5 days. So as you can see here, there's a contract action that is going on. They need me to approve what they're doing, and this is what he says. They're using this Goodrich case against me. He says there's no probability that the plaintiff will prevail, and that I'm to furnish a $10,000 security bond within 10 days. And if I don't, they're going to dismiss the case. And they're entering an order prohibiting me from filing any new litigation in the courts without approval from the presiding justice, which is actually a conflict of interest in this particular case, because the presiding justice already recused himself as having for conflict of interest. So what I did is I paid the fee, the layman advocate fee, for the Court of Indian Offenses, and this was my proof of that. The amount was $25. I had to set up a government account with the U.S. Department of Treasury. It's all done through this process. And then I attached the tentative ruling to make sure it was on record. So what I answered with was an amendment to the proposed order. Basically took exactly what he wrote and modified it. It it didn't really change it too much. I added the attorney because he's trying to keep himself out of it, but he was a defendant in the case, so he's there pro se. I put my IRA, Section 17 Tribal Corporation, the number from the certified mail. I put right there. That's our corporation number through that document. That's the document number. And then the executive agreement. This is another certified mail for the Secretary of State for that our executive agreements. And then that I'm now appearing as a CFR layman advocate because I paid my dues. And in order to be a layman advocate in the CFR court, you have to just show a basic understanding of American Indian law. And so so I modified his order. Plaintiff Jenna cannot be declared a vexatious litigant pursuant to California Procedure Section 391B2 and the Goodrich case, because here are the facts. The facts of that case do not comport with that action. The plaintiff was not reappointed to her position due to fitness concerns and failed to appear in the original decision. Plaintiff did not appeal in that case. After plaintiff's attorney withdrew from the case, plaintiff proceeded pro se. Plaintiff then filed 5 motions challenging the decision of the same case. Each motion was denied. The court found no legal, factual, or procedural basis to consider motions related to a matter that had been adjudicated and judgment entered. Defendant moved for an order declaring plaintiff a vexatious litigant in the Goodwin case, and they also, this was the first time, so that court had denied the motion that only 2 of Goodwin's filings occurred. So, and they affirmed the Holcomb. So before you even get to Goodrich, you still have to overcome the Holcomb affirmance. The court affirmed Holcomb in that case. The lower court. And the court determined the 2 filings were insufficient to support a determination that Goodrich is a vexatious litigant. The court stated, however, that its decision on the motion was without prejudice to renew if similar unsustained motions continue to be filed without any reasonable likelihood of success. Plaintiff, again appearing in propria persona, filed a motion for temporary and permanent injunction and related relief based on changed circumstances. Like the earlier motions, it attacked the validity of the judgment. Defendants moved again for an order declaring plaintiff a vexatious litigant. So she continued even after the admonishment of the court, and the facts of our case clearly do not fall within that definition. The court granted the motion, finding it has reached the point at which Goodwin is repeatedly relitigating claims against Sierra Vista, especially in light of this court's multiple prior admonitions. The court determined that her actions were unreasonably impacting Sierra Vista, and the court, as contemplated by section 31.9 subsection B 2 and 3. The trial court ordered plaintiff to post bond in the amount of $25,000 as security to proceed any further in this action. It further issued a pre-filing order prohibiting plaintiff, while acting in propria persona, from filing new motions in the action or any new litigation against the defendant without prior leave of court. Defendant appealed. So even when you get to the point of Goodrich, the court still limited its punishment to the litigation and not all the state of California. The court in Goodrich affirmed the lower court's ruling, held, as stated in Morton Supra, as few as 3 motions might form the basis for a vexatious litigant designation, where they all seek the same exact relief, which has already been denied, or all relate to the same judgment. Morton concluded that 3 motions filed over the course of 3 years and related to 3 separate judgments were insufficient to show that the defendant repeatedly filed motions within the meaning of the vexatious litigant statute. Morton. The court stressed that all three of defendants' motions relied on established and favored procedures for petitioning the court to modify or reconsider their order. Once appellant moved to reconsider the original order and the request was denied, he did not continue to petition the court for redress in suspicious or unconventional ways. He accepted the judgment and orders and sought redress from the reviewing court. The court pointed out, however, that this is not to say that only three motions could never form the basis for a vexatious litigate designation, where perhaps they all seek the exact same relief which has already been denied, or all relate to the same judgment or order and are filed in close succession. Morton. Although this statement is dicta, the court contemplated that a party could properly be declared a vexatious litigant based on the conduct that occurred here, i.e., the filing of three motions in the same court seeking the same relief relating to the same final judgment. This is particularly true where, as here, the party was admonished after two such filings that the request to designate the party a vexatious litigant could be renewed if similar unsustained motions continue to be filed without any reasonable likelihood of success. Holcomb supports this conclusion. The court in that case determined that two attempts at relitigation alone were insufficient to establish that a party has repeatedly relitigated a matter that has been finally determined. But the court based its decision on the record before it and not on the number of relitigation attempts. It determined that since the purpose of the vexatious litigant statute is to prevent future harm based on a litigant's past behavior, the legislature's use of the adverb repeatedly refers to a past pattern or practice on the part of the litigant that carries the risk of repetition in the case at hand. That risk of repetition was not present in Holcomb. So if we didn't reach the level of Holcomb, how can you reach the level of Goodrich? Here, there is no question that at the time the trial court declared Goodrich vexatious litigant, there was a past pattern or practice on her part that carried the risk of repetition. Now, that risk of repetition means of filing a claim that doesn't have merit, or that because the court found no basis in law or fact for her to do. And we have had no such prior ruling against us. She already had made two prior litigation attempts, causing the trial court to admonish that any further attempt could result in a vexatious litigant finding. And also in this case, the biggest thing that that was against her is that she failed to appear and didn't appeal the ruling against her. So she was at fault from the beginning. As Holcomb aptly observed, the risk of repetition is fairly easy to demonstrate in situations where the defendant seeking security has been the target of previous litigation attempts. Holcomb further noted that although Section 391 Subdivision B2 does not require a connection between the previous litigation attempts and the movement or action in which security is sought, such a connection would militate heavily in favor of requiring the plaintiff to provide security. Holcomb. That connection exists here. In each instance, Goodrich attempted to relitigate the same issue against the same defendant, Morton. Parties are entitled to rely on the finality of a judgment. In the case for that, after the time to appeal has passed, the trial court explicitly told Goodrich that there is no legal, factual, or procedural basis to again consider motions related to a matter that has been adjudicated and judgment entered. The facts reflected in the record. So that was A and B, and this is C. The facts reflected in the record and transcripts. Harmful error preserved. C. Jamison v. Desta, and that's California Supreme Court, 2018, because they held a trial without my court reporter, so everything. That was a harmful error. In that case, that kind of procedure is called a harmful error, and is ruled against the other party in the court. Because the facts in the record and transcripts do not fall within the scope of Goodrich, like a square peg in a round hole, there having been no final determination upon the fact of conversion by selling plaintiff's vehicle before final judgment in violation of California Civil Code Section 3070 C4 and D, and voiding defendant's lien pursuant to California Civil Code 3071 L. This case is an original proceeding. And D, Goodrich did not carve out an exception to or swallow up the two-filing rule of Holcomb with the determinative factor of risk of repetition. So that's what they were trying to use. Oh, well, you're a risk of repetition, when they didn't even have facts enough, and it doesn't that didn't overrule Holcomb's two-filing rule. It, as a matter of fact, it confirms it, that you have to reach the level of Holcomb before you even get to Goodrich. There is a reasonable probability that the plaintiff will prevail in the litigation against the movie defendants Finch and Hobson for the following reasons. It being a contempt of court pursuant to California Code of Civil Procedure, Section 1209, 4, 5, 7, 9, and 12, the court cannot refuse to take notice of the federal court order in case Jejena v. Finch. A final determination upon the informa pauperis pre-screening procedure. The court determined ordinarily a case dismissed for lack of jurisdiction or lack of subject matter jurisdiction should be dismissed without prejudice, so that the plaintiff may reassert his claims in a court of competent jurisdiction. See Fireguard v. United States, 1988. And 3. If plaintiff Jejena were to furnish with the clerk of the court for the benefit of the moving defendants Finch and Hobson a security bond in the amount of $10,000 before the counting of 10 days, they must fill out a IRS form 8300, which is anything over $10,000. You have to fill out this IRS form 8300. And it's a suspicious activity report as well, and serve it upon the plaintiff to complete and turn over to the IRS and U.S. Treasury. If the IRS form 8300 is not served to initiate deposit of the instrument, this case would have to proceed upon the waiver of defendant's request for the security. Number 4, as the plaintiff has paid his dues to the CFR Court of Indian Offenses for a layman advocate, defendant's claims are moot, and the court cannot pursue cannot pursuant to California Code of Civil Procedure Section 391.7 issue the pre-filing order vexatious litigate be entered upon plaintiff Jenna from filing any new litigations in the courts of California without approval of the presiding justice or presiding judge of the court in which the action is filed. Because a layman advocate, what that is it allows you to practice in the CFR court with a basic knowledge of Indian law. And so because I am now an advocate, I am no longer acting as pro se. Because I represent the tribe. And then this court adopts its tentative ruling in favor of the plaintiff, and then I had the judge sign it. And then this I approved as to form and content. So I approved it. Okay? And then I attached the letter, his proposed order, the payment for my advocacy dues, and the tentative ruling. I should have attached the form 8300, but we had already left the house and I didn't feel like turning around, and it's readily available online. And of course, we don't only send it to the attorney, we send it to the Office of Tribal Justice, the DOJ, and to the Office of Native American Affairs, which is the tribal liaison for tribes, the state, and the and the federal government. And we went down to go file it. The clerk, they stamped it received. The clerk, she was looking at it and she didn't know what was up because the tentative ruling, because she's reading the tentative ruling, right? And she gave me a copy. And it clearly says, off the bat, it says that their motion was denied. And she goes and reads further, and she says, there's something really, really janky about this. That was the tentative ruling that we read before. So right there, they're holding court before there's a court reporter, and then that preserved my objection and the error. And she tried to say that she corrected the error, but it was too late. There's no record for them to go off of, so there's no substantial evidence to even for the court to even infer a ruling against me under Goodrich. They don't have any evidence, but so the clerk said that it looks really janky because all of a sudden they're ruling in my favor and then they're ruling against me, and there's no substantive fact noted on the record. There's no facts noted on this record for the court not to adopt the tentative ruling. And the thing is that these are administrative courts. They're very limited in their at this point, it's administrative in nature. That they were administratively in my favor according to the facts and Holcomb, and because of that, administratively, they still have to be in my favor according to Goodrich. And so they didn't know what to do. The clerk above, the thing is I'm very, they know me by first name. We have a professional relationship that they know me. They know that my skills in the law have progressed, even in this last year, and they've been giving me that. They give me that respect as much as they can, and and they were like, "Oh, we can't accept this," and I said, "Well, you're going to have to file it on demand, and the judge will see it, and if there's any problems, you can come down to my house and arrest me for contempt. But you're going to file this, come to my side, come to my side of the line, basically, because my orders are from Calaveras, and if you're going to want to arrest me, you're going to have to come to my side of the line and arrest me for contempt. But it's clear that the order is baseless. It's the reason why I'm not even listening to it. It has no foundation to even convince me. And because you're asking for my approval, I assume you're still trying to make a contract with me. So we filed that yesterday. And then we also finally wrote our letter to another letter to the president through the senior advisor, Thomas E. Perez. I wrote it care of Thomas E. Perez. That way, it would be sure that the president received it. And so Thomas E. Perez is the senior advisor to the president and director of intergovernmental affairs. And so that's where we're at. We paid our dues to the advocacy program, and I'm hoping that I'm giving guidance to enough to where those after me can learn this process and see and hopefully it works for you as well as it's working for me, because the thing is that you got to be willing to fight for your rights all the way to the Supreme Court, because if they're going to do whatever they want. But bottom line, the Supreme Court has the final say in certain determinations, unless it's in the final say on issues of interpretation of law. And so, well, I'm going to cut this video short, and hope you guys have a good day and good week and good life, and take care. Keep fighting. Peace out.